Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk a little bit about certain things that occur by operation of law under immigration law, and what exactly does that mean? Okay. First, you want to take into consideration that there are a lot of different applications that you can put forward in immigration law. Okay, and that means that you apply, for example, for an H-1B, you apply for another non-immigrant type visa, you apply for asylum, you can apply for adjustment of status, you can apply for naturalization. I mean, all these different things are when you are affirmatively applying for something at immigration. So, to give you an example, and one reason I'm bringing this up is over the last few years I've had several people who haven't understood the exact parameters of why or when something changes by operation of law and how that might affect them. There's one incident in particular that this would apply to. Let us say that a lawful permanent resident father petitions his daughter who's 18 years old, okay? And everything is fine. And then let's say that the visa number has not yet become current and the daughter turns 21, okay? Then what I have found in many cases is people think, well, it was under preference, under one category of the second preference, and now since my daughter is over 21 years old, that preference no longer applies, therefore I need to re-petition her again. Well, that's not the case. That's not what happens. And there's people who have lost years of waiting time on the visa priority chart because they thought that they had to again re-petition. So let me tell you what happens. Using the same example, and there's different ones as well, with the same family type petition. Let's say that the father petitions the daughter who's under 18 and the father is a lawful permanent resident. Well, that would be basically the second preference, the first category. And then what happens is when the daughter turns over 21, you now have a lawful permanent resident petitioning a daughter, son or daughter who's over 21, who's no longer a child under immigration law. And what happens is by operation of law, it automatically changes preference to the other second preference category. And what operation by law means is that there's nothing you have to do, there's nobody you have to notify, there's nothing that needs to be filed. It just automatically changes the moment that the daughter turned 21. So how can we use the same exact example except change a little bit to show additionally how it would work? Let's say that the again, the daughter turned 21 and the father was a lawful permanent resident, but then he took his naturalization exam and he became a U.S. citizen. So now you have a U.S. citizen who had petitioned his daughter as a lawful permanent resident. So what does that mean? Well, now it has moved to the first preference because the father's a U.S. citizen. And again, nothing he needs to do, there's nobody he needs to notify and so forth. It happens by operation of law. Now that doesn't mean, in this case, that he shouldn't send the NVC notification that he's now a U.S. citizen so that they know that by operation of law the category had changed and moved to a different preference. Okay, so let's continue. Let's continue the same example. Let's say that the father became a U.S. citizen. The daughter was over 21. Again, that moved from the second preference, first category, over to the first preference. But now let's say that the daughter gets married. Okay, so now you have a U.S. citizen who has petitioned a married son or daughter over 21. That moves it to third preference. Okay, so automatically now the preference has changed to third preference. Now let me give you what a lot of people don't know happens, unfortunately. Let's say that the father did not become a U.S. citizen, and let's say he was still a lawful permanent resident, but the daughter turned over 21. That's fine. That just changes the second preference category. But now let's say the daughter gets married. Well, what has happened now? Well, by operation of law, it didn't change preferences because there is no preference for a lawful permanent resident petitioning a married son or daughter. So by operation of law, that particular petition now is terminated. It's voided. Okay, it no longer exists. And even if the daughter gets divorced, the petition is gone. So unfortunately, sometimes people will wait years and years and years to for a visa number to become current. They'll get married and not to realize that unfortunately the petition has been voided. Now, what are some other examples here? Well, let's say that the father became a U.S. citizen, but he did so before the daughter turned 21. In that particular case, it no longer is a preference petition. It now moves to what's called an immediate relative petition, upon which he can basically either consular process her, or she can do an adjustment of status right away. She also falls under the CSPA. Her age has been locked in at whatever it is when he became a U.S. citizen, as long as she was under 21. And as old as she gets, she will be considered under 21 under immigration law. So you can see with this one example all the different variations that it can occur, but hopefully now you'll understand a bit about how operation of law will, through immigration law, will make things happen automatically without anything else once the conditions are satisfied. And I'm giving you this particular example, but in fact there are lots of different examples under immigration law where by operation of law things happen automatically. But I thought this would be a good example to get your feet wet on the issue. Okay, if you like the video, click like, subscribe, and give my office a call or email if you'd like a consultation. More on the coming videos.